Revenue, please go ahead. My question goes to Dr. Igartua. You said that the way that the law is drafted means that the message that is being conveyed to young people will, depending on how it is drafted, that is marijuana. The consumption of marijuana will be normalized or not. Now, in the federal bill, there will be the permission, the authorization for people under 18 to possess a certain amount of cannabis. The bill also provides that people who are 18 and over can consume it. Now, do you think that if the right to possess had been removed from people age 18 and under, if it had moved to age 21, would that not be a way of sending a message to young people that consuming marijuana is dangerous?
Anyone?
Ben, je peux y répondre.
Well, I can answer if no one else wants to.
Moi aussi.
I thank you. Senator Gold, followed by Senator Batters and Senator Pate.
Thank you. Although my question was asked by Senator Pratt, Mr. Bryant, I'd like to come back to you for a second, because in the briefs of the Canadian Bar Association, the Bar of Quebec, there's some very specific recommendations which are helpful, and thank you for the care with which you presented your memoir. But I'm having a hard time grasping exactly what you would recommend that we do. I mean, I understand your point about taking a non-criminal law approach to this, but we've got a bill in front of us. Mm-hmm. So are there any, and I'm not asking you to draft them for us, but are there specific amendments that you would either recommend or that you would support in the briefs that we've had that would improve the law, at least from your point of view?
I take your point, and it was, this is the challenge is whether or not one comes in and sort of enables a process that the argument is it ought to have been commenced and determined through a different ministry. But nevertheless, we adopt and with support the recommendations made by both the CBA and the Barreau du Quebec. And also, I should add, I want to thank Mr. Calarco for his assistance. All my errors are my own, believe me, but he was of great assistance to me in leading up to this bill. And the recommendations that they have made, we would echo. The other specific matters that don't fall within it would be with respect to the search powers and the entire section on search powers and the entire section on forfeiture of property, because there already is forfeiture of property powers. There already is search powers under the criminal code. And so in the event that police believe that criminal activity is taking place, then they have those powers to turn to. But these particular search powers are problematic in part because it opens up the searches to property in circumstances that really are just for criminal matters. It is just under it is justified in criminal matters that you would have the police coming in without a warrant to do a search of a property. And so by putting this in this particular bill, what we're doing is obviously exposing Canadians' liberties. Personal liberties, not just their property, but their personal liberties and the experience of having a search being conducted on them without a warrant.
Mr. Batters.